through the web. If there's anyone who cannot see what's on the screen now, you should be having the first slide in the presentation. Just let me know by chat. Otherwise, you should all have the presentation on your screen. The topic for this month's webinar, I should say, is employee data privacy and the EU GDPR regulations 2018. What Nigerian businesses need to know. Our presenter for today is Josephine Udonsak, who is an associate in the law firm of Adepetun, Caxton Martins, Agbo, and Shegun. She is currently running a program at the University of Aberdeen, Scotland, where she's writing LLM thesis on the EU privacy law. And we thought that with that background, she's probably best placed to give this talk on these GDPR regulations. Without going into the substance of the presenter's presentation, I should just give the general background that the GDPR is a privacy regulation that has just been rolled out by the European Union. It took effect from the 25th of May 2018. And because of its, some of its provisions, it's not clear in terms of enforcement apply to companies outside of the European Union, which is why we thought we should give this webinar a shot, because if you have been observant, you would have noticed a lot of emails from majorly tech businesses and then companies, especially those companies with subsidiaries or affiliates, you know, in different parts of the world, sending emails about updating their privacy policies to comply with the GDPR regulations. So this webinar is going to give us an insight into what the GDPR is, what its objective is, what it covers, what it doesn't cover, whether it applies to countries or entities outside of the EU, whether we should be bothered as employers or you know, whether employers or businesses need to be bothered about these regulations. Okay, I seem to be getting some messages that some people can't hear. So before I hand over to Josephine, I'll just confirm again that everyone can hear me. 1 minute. Did everybody hear my introduction?
Yes, I did.
Yeah, I did.
I did.
Okay.
I did.
Hear me now? Hello, Nena. Okay, we'll sort that out. I'm going to hand over to Josephine now to start a presentation. Josephine, please.
All right, thank you, Jamie. Thank you very much for that introduction. Welcome to everybody. Thank you to Jamie and the administration of Ellen for having me do this presentation, and congratulations on the first webinar. Jamie has already introduced the topic, so I would just 1 second, please, guys. Jamie has already introduced the topic, so I'll just go on straight to give the outline and go into the presentation itself. The presentation will give a general overview of the EU GDPR to start, and then go into the principles, the rights, and the obligations provided under the GDPR. We'll look briefly at the specific GDPR provisions that deal with employee data privacy, and then we'll go on to talk about what Nigerian businesses need to know about employee data privacy and compliance with the GDPR. I'll conclude on that, and then I'll just have an extra slide that gives further reading. First of all, the GDPR is known as the EU regulation on the protection of natural persons with regard to the processing of personal data and on the free movement of such data. It repealed the 1995 EU directive on the protection of individuals with regard to the processing of personal data and on the free movement of such data. I should probably explain the difference between the EU directive and the EU regulation. As far as EU law is concerned, where there is a directive, it only gives certain results that must be achieved or that the directive seeks to achieve, but allows each member state to then decide how the directive is transposed into national law. The regulation, on the other hand, has binding legal force throughout the EU once it comes into force. So not every provision in the regulation is entirely new. Some of it was already in the directive, some of it was the scope definitely was extended, for instance, and other things were changed just to make it better. The aim is to provide stronger protection of the fundamental rights and freedom of natural persons in relation to the protection of personal data. The regulation was passed on the 27th of April 2016, but it only came into force on the 25th of May 2018. Now, the scope of the regulation, generally, it deals with the processing of personal data by controllers and processors. Processing refers to any operation or set of operations which is performed on personal data or on sets of data of personal data, whether or not by automated means such as collecting, recording, organization, structuring, storage, adaptation, alteration, retrieval, consultation, use, disclosure by transmission, dissemination, or otherwise making available, alignment or combination, restriction, erasure, destruction. So generally, it deals with um, almost anything we can actually do with personal data. The GDPR defines personal data as any information relating to an identified or identifiable natural person. Clearly, from that definition, it's clear that it doesn't seek to apply to companies or legal entities. It specifically applies only to natural persons. That's first of all. Then an identified or an identifiable person refers to someone who can be distinguished from other individuals using an identifier or a combination of identifiers. An identifier is any means through which an individual can be identified. For instance, by your name or by your address, or the GDPR has a non-exhaustive list of identifiers, which includes name, address, things like that. But it also includes online identifiers, which is like your IP address or stuff like that. So basically, any information someone has that they can use to identify you will be an identifier. A name is obviously the most common one, but I should point out that it's possible to identify a person without knowing his or her name by using a combination of other identifiers. So for instance, um, I work in ACAS law and I live in Surulere, and um, I'm the only person who works in ACAS law who lives in Surulere. Once you have once you have that information that I work in ACAS law, once you have the information that I live in Surulere, and once you know that there's only one person that lives in Surulere, you're able to identify me even though you don't have my name, because you can tell who lives there and where the person works, so it's easy to pick out who I am. So once you have any information that will lead you to identify somebody, that's an identifier, and such information will be considered personal data under the GDPR. Now, I've highlighted certain things in color to just point out the important aspects of that definition. So another thing that is highlighted is the part that says relating to, because it's not enough to just have information about somebody. It has to relate to that person. And what that means is the identity is key. Just like I explained, you have to be able to identify me, or my identity has to be important to what you are doing, if that makes sense to anybody. We can just take the questions at the end. So whether or not information relates to an individual will depend on its content and the purpose for which it is processed. Let's take, for example, again, in ACAS law. My data can be processed by the software that tracks our billing hours and how much we make. If you take my information, my name, how many hours I work a day, how much money I bring into the firm, blah blah blah, you can identify me. And if you take if you take all that information because you want to assess my performance, then my identity is important, and so that is personal data. But if a firm decides to take information of everybody in the firm who uses the software to track their hours just because they want to know how well the software is working and the identity of the people using it is not in question, then in that context, it would not necessarily be personal data because you're not identifying anybody. So for instance, instead of putting in Josephine clocked in 12 hours a day, you would just put A clocked in 12 hours a day, B clocked in 12 hours. Nobody cares about who is clocking in. They just want to know the hours and they just want to track how the software is performing. So in that instance, you're using the same, you may be using the same group of information or the same group of identifiers, but it may not necessarily be personal data in one context, even though it's personal data in another context. So that's it. And okay, another thing is that if data is completely anonymous, then it wouldn't be cut under the GDPR, because the GDPR has to deal with where an individual can be identified from the data. The GDPR also gives special attention to the processing of other categories of data, like special categories of personal data, which includes racial or ethnic groups, political opinions, religious or philosophical beliefs, trade union membership, genetic data, biometric data, health data, or data about an individual's sex life or sexual orientation. Basically, the special categories of data is just sensitive data that would that has a higher risk of threatening people's rights if the data is out there, basically. And then it also has special provision for personal data that relates to criminal convictions and offenses or related security measures. Special categories of data like racial and ethnic groups and all of that is prohibited on the processing of it is prohibited except under strict and specific conditions in the GDPR, while the processing of data relating to criminal convictions can only be processed in specified instances under the GDPR. So I've already talked about who an identifiable natural person is. I wouldn't repeat that. I'll just say that the controller is the person, the organization, or the person that determines the purpose and means of processing personal data, and the processor processes the personal data on behalf of the controller. It's possible that the controller can be the processor and the controller at the same time, but it's possible that they can be different entities. For instance, if you have a company that outsources its recruitment responsibilities, whatever, to another entity to help it process applications and decide who comes into the company and who doesn't come into the company. The company itself is the controller because it's the one who collects data and determines what to use with it. But the recruitment agency that is helping with the recruitment process will be the processor in that instance. And I've already explained how personal data, the same piece of data can be personal data in one context and not in another one. So I'll just move on to the next slide. More specifically on the scope, the GDPR deals with processing of personal data through specified means in the context of specified activities and by specified entities within or outside the EU. First of all, in this instance, there's the material scope and there's the territorial scope. The material scope, the GDPR clearly identifies that it regulates or seeks to regulate the processing of personal data wholly or partly by automated means. So basically, that's just computer processing of personal data, or processing of personal data which forms or is intended to form part of a filing system if the processing is done other than by automated means. A filing system is defined as any structured set of personal data that is accessible according to specific criteria, whether centralized, decentralized, or dispersed on a functional or geographical basis. An example of a filing system would just be a filing cabinet that contains HR records and is arranged in alphabetical order of employee names. What the GDPR doesn't apply to is activities which fall outside the scope of union law. Activities which fall outside the scope of union law will include national law of member states as it relates to criminal law or criminal activities or national security. The GDPR won't deal with activities in those areas. The GDPR would also not deal with processing of personal data by member states when they are carrying out activities that fall within um, Chapter 2 of Title V of the Treaty on the EU. And that portion of the Treaty on the EU deals with common foreign and security policy. The last thing the GDPR doesn't deal with is processing by a natural person in the course of purely or personal household activity. This exemption has been narrowly construed in cases in the past before the European Court of Justice, and I've included examples of two cases, Ryan's case and Linguist case. In the Ryan's case, basically, a guy put out, it wasn't personal data per se, he put out a CCTV camera in his house that was looking into a public space, and he did that because his house had been burgled. So it was basically for the security and safety of his property. The CCTV helped him identify two suspects the next time his house was burgled. And one of the suspects said his rights to privacy had been breached because he had no idea he was being videoed. And the court held that even though Rines was doing that in his personal capacity and for personal reasons, the fact that the CCTV camera was in a public space and was affecting public people, it wasn't purely personal household activity. So he was in breach of it. In the linguist case, the lady took information of some church members and she compiled it on her home computer and put it on an internet and put it out on an internet homepage, and it disclosed information of people in that group to other people. Obviously, she thought it would come under personal use, but the court said that it didn't. So basically, this exemption is understood strictly or construed strictly by the court. But what will come under activities like this will be personal correspondence or personal use of social networking service, but it wouldn't include activities that are partly personal and partly professional. The next thing is the territorial scope. Again, I highlighted some portions that are, I think, important in understanding the territorial scope of the GDPR. The first one is that it applies to processing of personal data in the context of activities of an establishment of a controller or a processor in the EU, whether the processing takes place in the EU or not. So if you have a company that's in the EU, and it's processing data of somebody, anybody really, any individual, whether the person is in the EU or not, it, those activities come under the GDPR, and the person has to look at entity has to comply with the GDPR, or the person has to comply with the GDPR. This first aid part obviously corrects the misunderstanding that the GDPR is only supposed to apply to EU citizens, because it's not. Any one of you in Nigeria or wherever you are, whether or not you're an EU citizen, the processing of your personal data has to be done in compliance with the GDPR. So it's not only protecting EU citizens, it's supposed to protect everybody in general. The second part of it is, and then I put there an example, if you have a company in the UK that has employees in Nigeria, processing of their personal data has to be done in accordance with the GDPR. And obviously, because the entities in the EU, it's not difficult to see how compliance will be dealt with in this first instance. In the second instance, processing of personal data of individuals who are in the EU by a controller or processor who is not in the EU, where the processing activities are related to either the offering of goods or services, irrespective of whether payment is required or not, and B, the monitoring of their behavior as far as their behavior takes place in the EU. So the first part of it that deals with entities that are offering goods or services is the part that will concern businesses in Nigeria. Clearly, from reading this, employee data isn't caught under this because in an employer and employee relationship, it's the employee who is offering the service and not the other way around. It's not the company offering the service to the employer. So this wouldn't employee data wouldn't come under B, um, in my opinion. And clearly, this is where enforcement might be an issue because how do you then deal with a company who is not in Nigeria, who is in Nigeria, but is offering goods and services to to a person in the EU? And what I can think of is, first of all, obviously by contract, is just to include terms that reflect the GDPR in the contract, just like people did with the Foreign Corrupt Practices Act and all of that. Another way to deal with it will be through international law, because in the C part, it says processing of personal data by a controller who is not established in the EU, but that is in a place where member state law applies by virtue of public international law. And what I can think of in respect of this is if you have, as a business in Nigeria, a contract that is subject to English law, my thinking is that you would immediately be caught under the GDPR. And that's just, I think, some of the ways that they may go around with enforcement for the B part. The second part of the B part says monitoring of their behavior as far as their behavior takes place in the EU. And that basically relates to tech companies that have to collect data online for the sake of profiling and all of that. So from looking at A, B, and C, the only place where I see that employee data would be caught is under A. And under A, where the employee data can be caught, it would only be if the establishment in Nigeria has a link with the establishment in the EU. That's my thinking on A because of the way it is phrased. So if you have a company in Nigeria that directly employs somebody in the EU, then I do not think that processing of employee data in that context will come under the GDPR. Again, it's weird to think about how you would employ somebody who is not in Nigeria, but then I don't know, maybe that's academic. But if you have a company in the UK or in the EU that employs somebody in the EU and then sends the person to Nigeria, the company in the UK has to comply with the GDPR. And if the person is, and if depending on the relationship between the Nigerian entity and the foreign entity, the foreign entity can always pass down the obligation to comply with the GDPR down to the Nigerian entity if they are linked, and obviously depending on what the recruitment and HR process in the company is. So that for me is where employee data and processing of employee data in accordance with the GDPR would be relevant. The principles, the rights, and the obligations under the GDPR. The GDPR gives 7 principles in accordance with which processing of personal data has to be carried out. Basically, what it means is that whenever you're processing data, you have to take into consideration these principles. And it also means that the other specific obligations and rights created under the GDPR just revolve around these principles, which are first one, lawfulness, fairness, and transparency. Which lawfulness just means that you have to process data on grounds that are permitted by the GDPR, or you have to have a lawful basis for processing personal data. And that would include either you have the clear consent of the individual to process personal data for a specific purpose or for more than one specific purpose. The second one, if you have a contract with a person and the processing of the person's personal data is necessary for the performance of that contract, or if the individual has asked that specific steps be taken before entering into the contract. The third thing that would give you um, lawful basis to process personal data is if you're processing it for legitimate interest that is pursued by the controller or by a third party. I've identified just three that are relevant in the context, that may be relevant in the context of employee data, because there are two more which relate specifically to member states and EU law, and I don't think is relevant for the purpose of this discussion. So legitimate processing is basically where you have a relationship with a person where it can be reasonably expected that you will process the person's data. An example of that is an employee and an employer. If I'm employed to work for a company, you can reasonably expect that the company would have to take my data for the purpose of that relationship and for the purpose of performing my obligations as an employee, and the company's obligations as an employee. So you could either process employee personal data on the basis of consent or on the basis of legitimate interest. And maybe also because it's necessary for the contract, because there's a contract of employment, so I think that would also pass. But what wouldn't be allowed under the GDPR is for you to pick and choose to try to come under a broad umbrella of lawful basis. For instance, you can't say that you're processing under both consent and legitimate interest because you want to be able to have something that covers you for everything. And when you do one thing, you say this is consent. When you do another one, you say it's legitimate interest. You have to pick one and stick with it, basically. Lawful processing also means that you can't do anything that is unlawful with the data that you have, such as breaching a legislation or breaching an agreement. Another thing I should mention about legitimate interest is that the element of reasonable expectation is important. So if as an employee and an employer, as an employee of a company, I can expect that the company would have my data, that's fine. What I wouldn't expect is that the company will collect my data and give it to somebody for a purpose that I would not expect to be done. For instance, it wouldn't be expected that you would collect your data of your employees and give it to a travel agency or a hotel that wants to market deals to stressed out executives. That would be a breach of the GDPR because I wouldn't expect you to do that as an employee. I think of it like confidentiality really. It's like why am I giving you my data? What basis do you have to have my data? Don't go beyond those expectations, or don't go beyond what I would think you would do with my data, or what a reasonable man would think you would do with my data. Legitimate processing under legitimate interest also comes with the responsibility to ensure that the right and the interest of the person's data who you are processing is adequately protected. So it's sort of, if you decide that you're going to process data on the basis of legitimate interest, then you have to go an extra mile in terms of protecting the person's rights, ensuring that the person's right to privacy in particular is not breached, which could lead to a risk to other rights that the person has. Regarding consent, which is one of the bases on which data can be processed under the GDPR lawfully, the GDPR sets out conditions for consent and gives a high standard in relation to asking for consent, recording it, and managing it. Basically, obviously you have to let the person know when you're getting consent, but there's also information that you have to disclose when you're asking for consent. You have to disclose the purpose for which you're processing the data, for instance. You have to disclose how long you think you would need to hold on to the data. You have to disclose when you would destroy the data after you have retained it for a certain period of time. If you can't specifically say how long you would hold it for, then you need to be able to say, give an indication of how you will determine when you've held it for long enough that you're going to destroy it, depending on what you want to use the data for. And then there's also the principle of fairness, which means that you should handle personal data in ways that is reasonably expected, and in ways that wouldn't have unjustified or adverse effects on the subject. Clearly, this depends on the circumstances of the case. It depends on how you obtain the data. And an example of where it wouldn't be fair to process that data is if you deceived somebody or if you misled the person when you were obtaining the personal data from the person. And then the last one is transparent processing under the A part, which just means that you have to be clear and open and honest about how you get the data, who you are, why you need the data, and how you want to use it. The second one is purpose limitation, and that principle is basically that personal data should be collected for specific, explicit, and legitimate purposes, and should only be processed for the purpose for which it is collected. So you can't tell me that you're using my data for marketing and then end up using it to profile me. That's an example of different purposes. So you can't take my data for health reasons and then use it for marketing. It wouldn't be the same purpose. The only time that you can use data for a different purpose from which you collected it for is if you get consent of the individual to ensure that the new processing is also done in a lawful and fair manner, and if the processing for the subsequent purpose is compatible with the initial purpose. So, and then there are other instances. The GDPR sort of gives a list of specific things that will be considered compatible with the purpose. If it's for archiving purposes in public interest, or scientific or research purpose, or statistical purpose, then the GDPR would it's deemed to be compatible with the initial purpose. Otherwise, you have to get consent again. In determining whether the subsequent purpose is compatible with the initial purpose, some things would be considered under the GDPR. For instance, if there's a link between the two of them, then you could go ahead and say that it's compatible. Or if the context in which personal data has been collected, or the context in which it has been collected in relation to the relationship between the individual and the controller. For instance, if my employer has my data, I can expect that they would use it to assess my performance. I can also expect that they would use it to for pension-related issues. I can also expect that they would use it for health insurance issues if you work with a company that sets up your health insurance for you. So those are compatible because they come under the employer and employee relationship. So you wouldn't need to, if you're processing employee data on the basis of consent, you wouldn't need to keep getting consent to use it for those different purposes. And then, okay, yes, and this is also linked to the transparency issue because the individual whose data is being processed should always know why the data is being processed. The next principle is data minimization, which just means that you should only collect personal data that is adequate, relevant, and limited to what is necessary in relation to the purpose for which it is processed. The GDPR doesn't define what adequate, relevant, or limited means, but it's one of those things that has to be understood in terms of the context. Accuracy means that whatever personal data you have has to be accurate, it has to be kept up to date when necessary, and data that is inaccurate should be erased or rectified without delay. For instance, if you have that my address is in VI, but my address is actually in Surulere, that would be inaccurate data and it has to be corrected. Storage limitation means that personal data should be stored in a form that permits identification of data subjects for no longer than is necessary for the purpose for which it was processed. So once you have my data and you've processed it and you no longer need my data, for instance, um, if I leave the company and the company no longer needs my data, then it should no longer store my data in a way that I can't be identified. But the GDPR recognizes that there are instances where even though an employee has left the employment of a certain organization, the organization would still need to hold on to the data. So those instances will be exempted. For instance, if you need to hold on to the data in order to provide for to make pension arrangements or or things like that, then you can hold on to the data. But things like emergency contact details or previous addresses may no longer be necessary, so it shouldn't be stored any longer by the company. The next one is integrity and confidentiality, and it basically means that personal data should be processed in a manner that ensures appropriate security of the personal data and protect it from unauthorized, unlawful processing, accidental loss, destruction, or damage, and that the company should use appropriate technical or organizational measures to store and process data. The last one is accountability, which basically means that the controller has to show compliance with the principles outlined in the GDPR. Um, this is usually done by keeping records. For instance, to show compliance with lawfulness, you would keep records to show that you got consent of the data subject to process that data and the likes. Any company that fails to comply with the principles of the GDPR is liable to an administrative fine of up to 20 million euros, or in the case of an undertaking, for up to 4% of the total worldwide turnover, annual turnover of the preceding financial year, whichever is higher. This administrative fine is specifically for non-compliance with the principles. It doesn't apply to it's not a penalty or for non-compliance with other specific provisions in the GDPR. So member states can go ahead to make laws for specific penalties. That comes within the GDPR leaves that for member states to deal with. This is just if you can't show that the way you have processed data is in line with any of these principles, then the fine comes in. The rights of the data subjects under the GDPR. The data subject essentially is the person whose data is being processed, and the GDPR gives a number of rights to the data subject, which includes most of it is self-explanatory, so I think I could just run through it. The right to be informed when you're collecting my data, basically let me know that you're collecting my data. Let me know why you are collecting my data, the lawful basis that you have for collecting my data. Let me know if you're going to transfer my data to a third country or to an international organization. Let me know how long you have to store my data, or give me an indication of this if you don't know how long. And let me know the rights that are available to me as the data subject. For instance, just tell me that I can change my mind and withdraw content if I want to, or things like that. Let me know what I can do in that relationship of data subject and controller. The next thing is the right to access. I should be able to ask for information about that you have about me and that you are processing about me. And I should be able to ask for all the things that I have a right to be informed about. For instance, I should be able to ask I have the right to ask why you're processing my data. I have the right to ask how long you're going to keep my data. I have the right to know what you know about me, why you know that about me, and all of that. A right to rectification. If I find out that you're processing my data and you have inaccurate data about me, I have the right to have that rectified. Or if the data is incomplete, I have the right to have it updated. Right to erasure or right to be forgotten. I have the right to ask you to stop processing personal data about me. And I have to give the grounds for that. If it's no longer necessary for the purpose for which it was collected, for instance, then I can ask that processing of my personal data be stopped. Or if I withdraw consent, then I can ask that you stop processing my personal data because I no longer consent to it. And then, or if I don't see any other ground for processing, then I can ask for it to stop. Another, and or if I object to being processed, because it's listed below, there's a right to object. Another right is the right to restrict processing. I have a right as an individual to restrict the processing of data. An example of an instance where this right can be exercised is if I find out that the accuracy of, if I contest the accuracy of the data that you're processing. I can say that until you verify whether that data is actually accurate or not, you should stop processing it. Or if the processing of the data is unlawful and I don't want to have it erased, I can say that instead of erasing it, you should just restrict how you use it or how you process it. Or if you no longer need my data for processing, but I need it because I want to be able to establish or exercise or defend a legal claim, then I can ask that you not erase it, but restrict how you process it. And then the next one is the right to data portability. That means that I have a right to receive personal data about me in a structured manner, in a format that is commonly used, and in a format that is machine readable. Machine readable just means that it can be understood and read by a computer. And I have a right to transmit the data that you have about me to another controller without any hindrance from you. I also have a right to ask you to directly transfer it to another controller instead of giving it to me. The next one is the right to object, which means that I can object at any time to the processing of my personal data. If you're processing that data based on consent that I gave, it basically means that I can withdraw consent to the processing. And the last one is right in relation to automated decision making and profiling. This means that I should not be subject to a decision making that is based solely on automated processing of data, like profiling. I think this is mostly tech related, so I wouldn't dwell on it too much. Basically, most of these rights where the individual has a right to ask for something from the controller, the GDPR requires the controller to respond as quickly as possible without undue delay. But it also allows the controller to either refuse to comply with the request made if it is manifestly unfounded or excessive, taking into account whether it's repetitive in nature or any other circumstance of the case. But the controller will have to justify its decision to refuse or to comply with any of the with a request based on any of those rights. The GDPR also gives the data subject a right to make a complaint to a supervisory authority, and if it feels that if the data subject feels that any provision of the GDPR is not being complied with by the controller, or if his rights are not being, if he's not being allowed to exercise his rights. A supervisory authority is an independent public authority of a member state that is responsible for monitoring the application of the GDPR. The GDPR also allows the data subject to rights to compensation and liability for material or non-material damage which arises from infringing on the GDPR. Obligations of the controller and the processor under the GDPR. The controller is required to use appropriate technical and organizational measures to ensure and be able to demonstrate that processing is done with in accordance with the GDPR. So appropriate technical measures, the GDPR allows for data protection by design and by default. That basically means that I think it's mostly for tech companies basically. So it means that the way you're processing my data, the software, for instance, that you use to process my data should have inbuilt technology to protect my data from breach or from being unlawfully accessed by other parties. And then, organizational measures just means that the company, for instance, should have adequate data protection policies in force. The GDPR recognizes the possibility of having joint controllers. For instance, if you have a company in the UK that has a subsidiary or an affiliate or parent company in Nigeria and is sending employees to the Nigerian entity, the the foreign entity and the Nigerian entity can both be considered joint controllers under the GDPR. Again, like I had mentioned, this would be one instance where the foreign entity passes the obligation to comply with the GDPR down to the Nigerian entity, depending on the relationship between them. So in the case where there are joint controllers of in case where there are joint controllers or where there are two organizations jointly processing data or collecting data for the purpose of processing it, the GDPR requires that both controllers have to determine the respective responsibility of each controller in a transparent manner. It basically means that if my data is being collected rather by A and B, I have to know who is responsible for complying with the GDPR. Who do I meet if I want to enforce any of my rights under the GDPR? Who do I speak to if I feel like any of my rights have been infringed? All of that thing. It has to be clear. You can't be pushing it back and forth between go to this person, go to this person. The GDPR wants it to be clear who is taking responsibility for compliance with the GDPR. It also allows an arrangement to be made between the joint controllers, but the arrangement does not preclude the individual from exercising his or her rights under the GDPR in respect of and against each of its controllers. The GDPR allows the controllers to designate a contact point for the data subject so that the data subject knows what to speak with. Another obligation under the GDPR is to use only processors that provide sufficient guarantees to implement appropriate technical and organizational measures for compliance with the GDPR. So if I'm collecting data as a company, but I'm not the one who is going to be processing the data, I have to ensure that the person who is processing the data uses measures that would ensure the protection of the rights of the data subject under the GDPR. The next obligation is to maintain a record of processing activities, but this doesn't apply to organizations that have less than 250 employees. The next obligation is to cooperate on requests with the supervisory authority where the supervisory authority seeks to perform any of its tasks. Another obligation is to notify supervisory authority of a personal data breach without undue delay, but no later than 72 hours after it becomes aware of the breach. If a breach is reported after 72 hours, the report has to be followed with an explanation as to why it wasn't reported within 72 hours. The exception to this is where the risk to the data subject that may arise as a result of that breach is unlikely. Personal data breach is defined in the GDPR as breach of security leading to the accidental or unlawful destruction, loss, alteration, or unauthorized disclosure of or access to personal data. The next obligation is to communicate a personal data breach to a data subject without undue delay, but again, not later than 72 hours after the breach, where the breach is likely to result in a high risk to the rights and freedoms of natural persons. And the last one is to carry out data protection impact assessment, where new technologies are going to be used for processing, and if the risk is going to, if the data protection impact assessment shows that there's likely to be a high risk resulting from the use of such new technologies, then the company has to consult the supervisory authority before using such new technology. Um, Specific GDPR provisions on employee data privacy. The GDPR contains a specific provision that allows member states to make more specific rules or laws with respect to employee data in the employment context, just to ensure the protection of the rights and freedoms of individuals. An example is if there is a loophole or a specific instance relating to employee data that is not dealt with in the GDPR, member state laws are allowed to um, deal with that at the end. Member state laws are allowed to deal with that in their own national law. An example of this is if you have um, where the GDPR requires you to store information only for the period that is required. The GDPR doesn't specify with respect to employee data in in an employment context what that retention period will be. In essence, after an employee has left your employment, how long after that how long after that after he leaves should you retain his data? The GDPR doesn't deal with that, but it's one thing where um, member state law can legislate on and specify and give a statutory period for retaining personal data. Another instance is where an employee, where a company processes personal data of individuals who apply to the company and are unsuccessful. So after the recruitment process, how long do you have to keep the data before you delete it? What Nigerian businesses need to know about employee data privacy and compliance with the GDPR. Compliance with the GDPR by Nigerian entities is contemplated, and interested parties will seek ways to ensure compliance with it. Specifically, the GDPR contains provisions on transfer of personal data outside of the EU. So if you have a foreign entity that needs, for instance, to transfer employee data to a Nigerian entity, the GDPR provides that such transfer of personal data can only be done on the basis of an adequacy decision by the European Commission. An adequacy decision is basically where the Commission considers that the country or the organization that you're transferring data to has or will take adequate measures or has adequate measures in place to protect personal data of such individual at the standard required of the GDPR. And if that decision is not reached, then the only other instance in which an EU entity can transfer data to a Nigerian entity is subject to the controller or the processor, which is the EU entity, providing appropriate safeguards, and on the condition that enforceable data subject rights and effective legal remedies for data subjects are available. So what the EU entities will be using in instances like this will be binding corporate rules. They will just say that all entities of the company has to comply with certain rules but as it relates to data protection or they would have standard data protection clauses, approved codes of conduct, and certification mechanisms. In this case, approved codes of conduct and certification mechanisms are as approved by the European Commission, not just by the EU entity. And then the GDPR also states that European Commission is to take appropriate steps to ensure international cooperation for the protection of personal data. And I put a note that since the rights sought to be protected by the GDPR are personal rights, it can be expected that persons in the EU who, one way or another, are employed by Nigerian entities or who, for whatever reason, may not be entitled to benefit directly from the provisions of the GDPR, may seek alternative measures of ensuring that their data privacy rights are still protected. So, in conclusion, I think that the GDPR applies to personal data, and this may include employee data. Whether or not it applies to a Nigerian entity as an employer will depend on the circumstances of the case and the nature of the relationship or the link between the Nigerian entity and the employee. And when necessary and depending on the circumstance, compliance with the GDPR by a Nigerian entity as an employer may be secured either by relying on relevant provisions of the GDPR or by seeking alternative means to do so. I've attached a link to the GDPR for anyone who may be interested. I've also attached guidance notes from the Information Commissioner's Office of the UK, which gives more details on the GDPR and how it is expected to work. And I'll hand over to Jamie now to moderate the questions and answer session. Thank you very much.
Okay, yes, thank you, Josephine, for the presentation. Very enlightening, I must say, even if most of it seems to be going over, well, my own head in terms of the sophistication. Let me not preempt people by asking questions first. I'm going to, I haven't seen any indication that anybody wants to ask questions. Okay, Olumide just raised his hand. I'm going to unmute him shortly. But just again, in case you all missed my chat that was sent to everyone, the way it works is if you want to ask a question, you have a number of options. You may raise your hands. There's a raise hand icon or button somewhere on your screen, depending on whether you're using a desktop or your phone. You can do that, or just type your questions and send to me by chat using the app also, and then I can read your questions out to the presenter. So Olumide has raised his hand to ask a question. I'm going to unmute him now. Hello, Olumide.
Yes, can you hear me now?
Yes, please.
Okay, thank you. Josephine, that was a fantastic one. It was a fantastic one.
Thank you very much.
Yeah. First, I have about 3 questions actually.
Jesus. Okay.
Okay, so the first one, I really want to know whether, I didn't get that part. Maybe I hadn't joined at that time. Is telephone numbers also part of the data protected? That's one. And secondly, does the GDPR specify the categories of law enforcement agencies that can access this data? Because I know that while most data protection laws would also make provision for some external bodies to be able to either apply or demand or request for whoever is storing those data to provide them with them. Then the other one is the sanction. Now I see the part of the sanction that has to do with fines. And whenever one sees fines, one thinks, oh, it has to do with criminal sanctions and everything. Now, someone who is a victim of such data violation, does he or she have any other course of action under that GDPR? Because when you talk about fine, then you are talking about, I'm not even clear as to where the fine goes to now. The fine goes to EU, I think. But what about the victims? Is there any provision for them? Thank you.
Good question. Okay, Jasmine, you want to take that?
Yes, please. So first of all, the first question, whether telephone numbers are part of the data. I did explain this at the beginning. Telephone numbers can be part of the data if you have a telephone number and you have other information about the person that would lead you to identify the person. If you have a telephone number and the name, that's clearly personal data because I have the number and I have the name, I know who it is. If I have a telephone number and an address, I know who you're talking about, I can identify the person. So under the GDPR, whether or not a piece of information will be considered personal data or not, is if I can use that information either alone or in a combination with other pieces of information to identify a particular individual. Does that make sense?
Yeah, it does.
Okay.
Yeah.
All right. The second thing is, does it specify regulatory bodies that can access the data? This is interesting. It does, right? It does specify regulatory bodies that can access the data, but because it's an EU-centered regulation, the only regulatory bodies that the GDPR recognizes are regulatory bodies in the EU. I probably should have mentioned that, but that's the reason why I left it out. It's specified in the EU, but it's one of the things where it's only regulatory bodies in the EU that are recognized under the GDPR. That's not to say that it's impossible. I mean, it would not make sense if they don't realize the fact that as a Nigerian, I have to comply with what the EFCC says. It wouldn't make sense. If you have a foreign entity that you have to report to, they would have to deal with it because I have to comply with my own laws as well. I can't be bound to your laws at the expense of my own laws. So it's not specifically provided under the GDPR, but the GDPR just came in force in 2018, and everybody, like a month ago or so, and everybody's still trying to make sense of it. So I'm sure it's something that would come up and have to be dealt with, but as at the moment, it's not. It just recognizes regulatory bodies in the EU, but it does have that provision that if you're legally required to disclose data for regulatory reasons, you have to comply. Does that make sense?
Yeah, it does. It does.
Okay. And then as for the sanctions and fine, the fine that is specified, the 20 million fine is an administrative fine. So your guess is as good as mine. My guess is that it will go to the European Commission. My thinking rather is that it will go to the European Commission. But yes, the GDPR does allow, and I think it's in one of my slides, I'll just go back to look for it. The GDPR does take into consideration individuals who may be aggrieved or yeah. So I'll just find where I had that. Yes, on this slide that I'm showing right now, Article 82 of the GDPR allows for compensation and liability for material or non-material damage which results from infringing the GDPR.
Okay.
Good. Thank you. Thank you.
You're welcome.
Hello. Hello. Hello.
I can hear you, John. Are you saying hello?
Okay. Yes.
Okay,
Okay. So you
sorry,
finished with Olumide,
yes,
right?
Yes.
Okay.
I'm done with this question.
Okay. So no one else, as far as I can see, has indicated an interest to ask a question. But I have a question of my own. I think for me, let me just put it as simple as I can put it, because in all of this, I know it's still early days yet, like you said.
Yeah.
Is there any reason why we as in-house counsel, for instance, should be advising our businesses, our companies to comply with the spirit of this law? I know there will be so much, like you said, I've been going through literature on the issue, and I know that no one really can come out to say, oh, this is how this will play out. But, you know, there are things about um, uh, an EU entity having affiliates in Nigeria, for instance, or an EU data subject working in a Nigerian entity, and a contract outside of the EU enforced or being implemented in Nigeria, I mean, with EU law being applicable to that contract, for instance. So with all of these dynamics, I'm sure, for instance, especially because of how we like to draft our contracts here, you see we have so many contracts here that are subject to, for instance. So I would like to know, with all of these dynamics and all of these different facets by which, you know, this GDPR can apply, can we confidently say that this law should be taken cognizance of by Nigerian businesses or not? Is it a matter of being erring on the side of caution, or is it a question of us saying, look, looking at it, there's no way you are not going to be caught up by, you know, any of all these facets? Your opinion, please.
Okay. First of all, Jamie, if I may say, you're taking it outside the scope of this discussion because we're discussing
Oh, I see.
employee data, but that's
Oh,
fine.
employee data, yeah.
I do have an opinion. So, if you're talking about Nigerian businesses complying, yes, like I said, I've put up the relevant slide. If you're
Okay.
if as a Nigerian entity that is offering goods or services to an individual in the EU, not an entity now, an individual in the EU, you're definitely
Okay.
caught under the GDPR. And like I mentioned, one of the easiest ways to get you to comply is to make it subject to English law. Because the C part says if you're not established in the EU, but you're in a place where member state law applies by virtue of public international law, then you have to comply with the GDPR. My limited knowledge of public international law, I'm thinking that if your contract is governed by English law, English law would definitely take into consideration the GDPR. Not only will English law take into consideration the GDPR, the English law also has the Data Protection Act, which nationalizes the GDPR and even goes beyond the GDPR to make tighter provisions on specific matters, like the employee one that I mentioned. So if you have a contract that is subject to English law, I don't think you can get away from it. That's just, like I said, one way that people will try to make sure that Nigerian businesses comply. The one that is more difficult and that I can't immediately think of how they will get people to comply is monitoring of their behavior as far as the behavior takes place in the EU. Because if you have a Nigerian tech company, for instance, that is collecting information from people who are in the EU and they don't have or they cannot be seen to be complying with this, then how do you enforce it? That's the one that I think is tricky. But generally speaking, with this whole extraterritorial scope and Nigerian businesses, my position is this. It's an issue of development. Whether we like it or not, data privacy laws are here to stay. And if we're going to, well, I can either get left behind or we can get caught up with the globalization process and try and start trying to imbibe the spirit of it. Because what you will see is that if people just know that Nigerian businesses are not going to comply, then they will try to boycott us as much as possible. For instance, let's say the tech company that needs to get data from people online for profiling and all of those things. Once people don't see that you have, I'm sure we would have noticed now, like if you want to go on a website to see like cookies and they tell you to accept their privacy policy and they tell you to give consent to marketing, to using your data for marketing, give consent to using your data for profiling. all of that has taken a step further now because of the GDPR. If somebody in the EU goes on your website and they just see that you don't have all of those things, they will immediately not even use your website. They'll just shut it down and move on to another one. So it depends on where you want to stand. That's one thing. And like I said, the data privacy issues are not going anywhere because of how important free movement of data across borders is getting because of technology. It's getting more and more important, and the essence of the GDPR really is to ensure free movement of data, which means that I want you to be convinced that I will take care of your data properly and that I have adequate measures to protect your data, to protect your rights to privacy. But I also need you to do the same. That's why I would say that's why there's the transfer issue. So now that the GDPR has all of these measures in place, if they wouldn't want to deal with people who don't have those measures. So for instance, I know that the US and the EU have this privacy shield, which is an agreement or a framework for movement of data. I don't have too much details about it, but I've seen it in passing. And it came in before the agreement came into play before the GDPR, but it largely mirrors the GDPR. So the US has already put themselves in a position where they show that we're willing to be compliant with the GDPR. The only thing that they've now done is because they thought about it ahead, they will probably have negotiated a better way to deal with it. But that's just to make sure that as between the EU and the US, there's no problem with data flowing back and forth. And other countries have very sophisticated data protection laws as well. So it's unlikely that they would have issues with the GDPR. In fact, I was speaking with somebody who says that a lot of things in the GDPR are things that international organizations and big companies already do as a matter of good information governance and good practices. So the GDPR just legalizes those activities, but it wouldn't phase them. So when you now ask me whether I think Nigerian businesses should get with this, yes, because it just gives you a footing as to whether or not people want to deal with you or not, and where you want to stand with that.
Okay.
If that makes sense.
Thank you. I have, sorry, Nena. Nena needs to ask a question, but something just occurred to me. I just need to ask that quickly before Nena asks our own question. Now, I see that most of the focus of the GDPR is to protect EU citizens, right?
Yeah.
But the focus in terms of
No, not right. That's wrong, Jamie. And I mentioned that
Okay.
at the beginning. It's not EU citizens. You are protected
see.
under the GDPR as a Nigerian citizen.
Oh, really? Okay.
Yes,
Okay.
because especially with the APAT, an entity in the EU can't process your data without complying with the GDPR.
Oh, I see. Because I
So
was going to,
it's
my question was
everybody.
going to be yes, that most of these tech companies that do business in Nigeria. So if Facebook or Uber uses my personal information somehow here in
Yeah,
Nigeria,
yeah.
will I then not be protected because I'm not an
No,
EU
it's
citizen?
everybody. It's everybody. I mean, if Amazon in the UK is using your data in Nigeria, you're protected. But like I said, if if Nigerians are showing that, I mean, they would never cut us off really because it's for their benefit to protect everybody. So yes, everybody is protected.
So how do I then, as a Nigerian, you know, enforce this if there's a breach here in Nigeria against, say, Uber, for instance? Do I have to go to the European Union, European Commission?
Yes,
Okay. So
that's
I
my
can't file
thinking.
a suit here in Nigeria.
Um, um, I don't see how you can because unless Nigerian law recognizes it. But let me say this, and this is my thinking. Um, we need to remember that the GDPR is more or less the GDPR more or less directly flows from human rights issue,
Yes.
right? So I mean, it's a stretch, and that's another thing I was going to mention when you asked the first question, but I forgot. It's I because data privacy issues are here to stay, there's no saying how the international community will take it. There's no saying where the UN will take it in the next couple of years or whatever. But it can always be linked back to your fundamental human rights, which is the right to privacy, which is a right that is enshrined and that is also recognized under the UN Declaration of Human Rights. So anybody who can't find my thinking is that anybody who can't find a direct link um, to enforce the protection provided for under the GDPR would find some way to bring it under a human right. I don't know how that would play out, but that's my thinking. So
Thank you.
whether
Okay.
Nigerian law would whether it would be recognized under Nigerian law, I don't know. We know how Nigerian law is and how the courts would interpret it, and whether we care about privacy as much as others care about it.
Mm,
But
mm.
it's neither here nor there for Nigerian law.
Yeah, and if I may also chip in, sorry, on that, I noticed that if, for instance, you see most of these emails and notifications from all these companies notifying their users about these new privacy laws, you see
Yeah.
that it's written in a sort of a contractual format where they say, oh, this is our new privacy policy. This is how we will use your information. This is what we will do. This is what we will not do with your data. So I guess in a sense, it becomes sort of a agreement between the company and the consumer. So I guess if you're filing a suit here in Nigeria, for instance, you might probably try to go the contractual route to say, oh,
Exactly. That makes sense.
we had an agreement that this was how you're going to use my data.
That makes
Therefore, if
sense.
you've breached it, then I'm entitled to all those compensatory damages that you mentioned in the slides. Okay, thank you very much, very clear. So Nena has a question. I'm unmuting you right now. Nena.
Can you hear me?
Nena. Yes, now.
Hello.
Hello, Nena. Go ahead.
Okay. Hi, Jamil. Jasmine, thanks so much for the presentation.
You're welcome.
So I actually do not really have a question. I just wanted to comment on the first question that Jamil had asked as to how this concerns in-house counsel. I was just thinking that that question probably stems from the fact that you have some expatriates, for example, working and their employment contracts will just have this omnibus provision as to EU laws or the laws governing the respective jurisdictions in which the employee or the expatriate comes from. So that leads now to a thought on my mind as to whether it's possible for one to contract out the rights under this GDPR. I'm just thinking, I'm kind of playing devil's advocate. Like I know under Nigerian law, for example, there's a Supreme Court decision that you can actually waive some of your private rights, but if those rights impact on public policy, you cannot waive such rights. So can an employee by contract, for example, contract out of these laws, even though there is a general clause requiring compliance with EU laws or English law, whatever country in the EU that that employee comes from? Hello?
Hello.
Yeah,
Oh,
Jasmine.
when you asked me, I thought you were just making a comment. I think that's interesting to think about, honestly. Whether you can contract out of the GDPR. I can't think
Just
of.
because of the I'm sorry, Jasmine, just because of the complexity of it. Like I'm seeing that it's 88 pages long,
Yeah.
and an employer who really, is bullish might just say, you know what, I don't want to look at this 88-page document. We can just write one or two lines on your privacy in the contract and contract out of this. I'm just wondering
Okay.
how the EU is going to treat that.
Um. My what I would think about, or the way I would think about that is, how do I explain it? I don't think it would. Remember, there's also reputational risk involved, so I don't know how that would play out on the company, and if it's something you want to advise the company to do. What I would suggest instead, or how I would think about it instead, is that the company, um, the HR or the legal takes time to understand the GDPR and to have um, to have policies that imbibe the spirit and um, recognize the requirements and obligations of the GDPR. And so then you can contract and say that your data will be dealt with in accordance with the policies of the company, or have codes of conduct in the company, so that you don't have to be with every employee. You just know that as a company you are prepared to be compliant with the GDPR, if that makes sense. I think that I would rather look at it like that than trying to get an employee to contract out of it, because um you made a point about Nigerian law saying that you can contract out of your right, which honestly is new to me. And I don't know, I can't see how that will play out with the GDPR, and I can't. It depends on who it is, but I can't see people being willing to take that on without pushback or without repercussions in the future as to whether they even want to be dealing with Nigerians at all.
Hmm. Hmm. And then does that address your question?
Yeah, it makes sense. I was just looking at it from the other perspective. I'm not saying that I'm not recommending anyone to do that, but just looking at it holistically. There are some companies that would actually not care about their reputation, and some would even say it was a contract. The employee maybe understood the terms and decided to sign. There was no pressure or duress from any angle for the employee to sign. So it's a private right, unless we begin to look at it as something from a public policy perspective, in which
Hmm.
case we will not be able to contract out of it. But it's a private right, and just when I think you put it very well there, where you said that you could have a term that would just say, oh yes, you recognize the spirit or of the GDPR, but your data will be dealt with in accordance with the company's policy. That may be a bit safer, particularly because for companies that are not in that jurisdiction, I may not be able to keep up with the pace as to developments, changes, and revisions from time to time to go back and take care of. So I think this suggestion actually works. As well.
Hmm. Okay, if I may also chip in again,
Yeah.
thank God I have the privilege of chipping in every time because
You
I
hold the
know
mic.
I hold the mic because I know other people too might have comments, and of course those comments are welcome. If you also want to comment on anything, just let me know. But I think Nena has partly answered our own question, which is even under Nigerian law, which is not as sophisticated, when you're talking of waiver of rights, the law is clear, just the way you put it, that even you that you are the owner of the right, so to speak, you can only waive those rights that the society or the state does not have an interest in the sense that they are not rights that are put there on public for public policy reasons. So I am not sure how you can waive that right to privacy by consent to then mean, for instance, that a company can deal with employee data or invade employee privacy contrary to privacy laws like the GDPR. So, for instance, you can say, oh, we can install surveillance camera. I mean, of course, Josephine is going to say this is outside the scope of GDPR, right? But for instance, we can now put camera inside the toilet because we realize that people are hiding money in the toilet, or we can take your phone and send it to the NBA for the purpose of compiling election data without informing, because I think the background to this GDPR, at least from what I understand, from a current affairs perspective, is these data breaches they've been having recently in the EU space. You had Facebook selling data to Cambridge Analytica to influence elections in Nigeria and elsewhere. You had this dating sites, with data breaches, where married men were caught chasing women all around. And then you had which one again? There was also a cyber security company that was. So if these measures are then put in place, I don't think any company will get away with now saying, oh, we can only enforce this part, we can't enforce that part just because we can't keep up with the pace. So be notified that some of your rights, your privacy will actually be invaded as we deem fit, or we can only enforce it as far as we can assure you. I'm not sure that really would fly. Really, except so contracting out really may not be um, may not avail. That's what I think. My personal reason, whatever. Okay, we have two people waiting. Um, I'll let I'll read out Niyi's question, which came up first, and then I'll unmute Bayo to ask his question. Except if Niyi is able to ask verbally now, I will unmute you. If you're able to ask your questions, just go ahead, Niyi. Hold on. Uh, okay, Niyi, you're on. Hello,
Hello.
Niyi. Yeah, you're on.
Yeah. Good evening, everyone.
Good evening.
Good evening.
Jamie, thank you for the privilege. Sorry, I've been off and on. I don't know.
Yeah. Must be
But I
your
was able
internet.
to listen to some part of the presentation. Now, my question is this: I've had instances where, in a bid of a judgment creditor to recoup money from judgment debtor, he obtained a BVN and then he used the BVN number to file court process, so that a bank can then freeze the debtor's account. My question is, in this instance, what right does a judgment debtor have? I don't know whether you get my point.
Yes, I think I get your point. My first question is, are these parties subject to the GDPR? That would be my first question because I don't know who the parties are. So when you say judgment debtor and judgment creditor, are they just two Nigerian entities that the
No,
GDPR
no,
has?
no. We have, yeah, I heard you say that it applies to, even if you're a Nigerian, you are still covered under the
It
GDPR.
applies to you if you're a Nigerian, but it applies to you if you're a Nigerian and the person processing your data is in the EU.
It's
Yeah.
okay, okay. So
So
if both are Nigerian,
then
then
no, the GDPR doesn't avail.
do not
No,
apply. Okay, okay, okay. All right. Thank you.
you're welcome.
Yeah.
But it will be interesting just for the sake of knowing, Josephine, if you
Yeah.
have a if you have a Nigerian what's it called judgment, if Organiye that just asked the question
Mm,
owes Uber outstanding cab fares and Uber goes to court to
mm,
recover those fees, and
yeah.
Uber gets a judgment against him, and
Yeah.
then brings his BVN into the court proceedings and say, this is the BVN of the debtor.
Yeah.
Court, I think that's what he's saying. How
Okay,
does
I see what
GDPR
you're saying.
apply in
No,
that
but
instance?
it's the same thing now. What's his name? Uber would have gotten it from the bank, right?
Yes.
The bank is the Nigerian entity. The bank is the controller or the processor in this case.
Okay,
So
but how
what
about the
if
data
we're
subject?
dealing with
Who is the data subject?
the data subject is me whose
Yeah,
BVN was gotten. He's
yeah,
in Nigeria, right?
yeah,
And the bank is also a Nigerian entity.
yeah.
So Uber is just using your system to play you. That's
Mm.
what it would mean.
And so, but
Because
because I thought you said since Uber is,
yes, but Uber is
covered
not
by
the
GDPR.
controller of your data.
Okay.
Do you understand? So Uber is not the one who has
So, oh, they're not the
um,
ones using the data.
exactly. They're not the ones collecting the data. They're not the ones using the data.
Okay, so but the act of filing it in court to recover doesn't fall under use of data. Is that what you're saying?
I'm thinking about it too.
Mm. Okay, think about it. Let me unmute Bayo to ask his own questions. I think these are some of the complexities that we'll see in days to come or in years to come, whatever. Bayo, you're on.
Yes, thank you, Jamil. Justin, thanks for the presentation. I'm not
Okay.
sure whether I missed the part of it, but my concern is
Can you speak
what.
up just a little bit? I'm struggling to hear you.
All right, Justin. So, what is the effect of Brexit on GDPR? I mean, the UK is leaving the EU probably in 2000, sometime in 2016,
Yeah.
and we have organizations that have companies in the UK. If most banks in Nigeria, few top banks have, some entities in the UK. So what's going to be the effect of GDPR post Brexit? Are they still going to comply with that with the GDPR provision? Is there anything around that? Just because some of us, we have companies that are actually, UK entities, and we just want to know whether once you're out of the EU, then we can begin to look at another data privacy law that is applicable to the United Kingdom.
Okay.
I see,
Yeah.
So that's my question.
Okay. That's a very good question. The GDPR itself may not apply, but the UK just passed its own Data Protection Act. No, let me rephrase. The UK just passed a new Data Protection Act in 2018 to comply with the GDPR. Do you understand that? So the UK there was a Data Protection Act before, I think 95 or something, I can't remember. But because the regulation has come into force in 2018 before the UK has left the EU, or before the UK's leaving the EU has taken effect, the GDPR binds the UK, and one of the things that the UK has to do is to transpose the GDPR into national law, which it has done by passing its Data Protection Act of 2018. So the entities may not be bound under the GDPR depending on circumstances, but there's still the Data Protection Act of 2018, which is essentially the GDPR and even go a step further than the GDPR to give more specific provisions on certain matters.
Well, that's actually creating more layer of compliance issue for some organizations. If the UK law has gone a step further, I've not seen that law. I don't know that, but probably I'll go look into that. So while trying to comply with the EU GDPR, then you have to then look into the extra provisions that are probably not covered under GDPR, but applicable to the UK.
I should probably clarify. When I say it goes beyond, it's like the GDPR is a regulation. It's because it's a regulation and because it deals with so many member states. It wouldn't go into detail with every single thing and every single matter. So there are some things that will be left for member states to deal with. For instance, penalty provisions. There's an administrative fine for not complying with the principles or for not dealing in accordance with the principles of the GDPR, which is flexible and which is, in my opinion, will be hard for a company in the EU to come under. But specific penalty provisions may then be included in the Data Protection Act. That's number one. Other things like certain statutory periods. For instance, when do I have to destroy, when do I have to erase data after I've held it for a particular purpose? Like I used the example of a recruitment agency. If you go through a recruitment process and a particular applicant is not successful, how long do you have to hold on to his data or her data before you erase it? The GDPR doesn't specify how long you have to hold on to that data, but it's an area where the Data Protection Act may, I haven't looked at it in detail yet, but it's an area where the Data Protection Act may, or any other act in the EU may specify a retention period for data. So it's those kinds of things. It will still be within, like, it's largely the spirit of the GDPR, and it's largely the principles will still be the same, the 7 principles will be the same, the requirements, the obligations largely will be the same, just cases where they need to be specific. Another thing I mentioned was on, I'll just go back to that slide on, what's it called, employee data provision, where the GDPR specifically says, the slide is up now, you can see, where the GDPR specifically says that member states can make law or have collective agreements to provide for more specific rules to ensure protection of the rights and freedom in respect of processing of employees' personal data and the employment context. So it's just things like that that the Data Protection Act would then deal with. Is that fine? Does that answer your question? Hello? Hello?
Hello, Bayo. Bayo seems to be distracted. We can see his video. Abby? No, it's my own video.
Can you hear me now?
Yeah.
Yes, I'm fine with the explanation. Thanks so much. That is really very useful.
Yeah. Okay. Is there any other person that has a question? Okay, Onyeda Mola has a question. Let me just give me a few minutes. I'm having some issues with my. Oh, sorry. Back to meeting. Okay. Onyeda Mola has a question. I am unmuting you right now. Onye, you're on.
Okay, thank you, Jamie. Good evening, everyone. Thank
Good
you,
evening.
Josephine, for that presentation. It was very enlightening. Okay, I'm sure you will be tired of my outsourcing matters, but yet I want to relate this again to outsourcing. Imagine a case whereby, as an outsourcing company, I outsource staff to, say, Facebook. Would my company be bound by the GDPR? Because officially, those staff are my employees. They are not Facebook's employee. And Facebook is the one that is bound by the GDPR. So would my company have to come up with a policy that would be in line with the GDPR? Or would I be seen as a joint controller or joint processor or whatever of data under the GDPR such that I have to comply?
Is Facebook going to be processing their data as well?
No, okay. No,
let me ask, sorry, 1 second. When you say you're a Nigerian entity, right?
Yes.
And the individual in question is a Nigerian entity, right?
Okay, no, let me explain it.
Is a Nigerian person, is in Nigeria rather.
I'm a Nigerian company. I outsource staff. So I'm outsourcing some of my staff who are my employees officially to Facebook. Where, of course, in the course of their duties, they'll probably have to process data of whoever. So do I need to come up with a policy that will comply with GDPR, even though officially, since I am their employees, I shouldn't be covered by the EU because I'm not an EU entity. I shouldn't be covered by the GDPR because I'm not an EU entity. But because they'll be working with Facebook, do I need to come up with a policy that will have me covered?
Okay. I'm just looking over the. 1 second. I just want to look over what it says in the provision on territorial scope and relate the question to it.
Again, while you look for that, I'm trying to rephrase Onyeda Mola's question, and correct me if I'm wrong. I think what she's trying to say here is that does the application of the GDPR depend on the actual employer who has control of the employee's data? Is that a fair rephrase of your question?
Kind of, but now I'm not just, okay, I know we are limiting it to employee data, but I'm also trying to extend the question a bit because my employees will be processing data, not just their own data. They work for Facebook or let's say Google or whatever. They will be processing data belonging to many people from different places. So
okay,
I'm not
I see now. Okay,
yes.
I'll try to answer your question.
Okay. Thank you.
I'll try to answer it from 2 different angles. If you're sending your employees to Facebook or outsourcing your employees to Facebook, to work with Facebook, but they work for you.
Yes.
My thinking is that you, as a Nigerian entity in Nigeria, will not be caught under the GDPR. But Facebook, as an entity in the EU, will be
Yeah.
required to comply with the GDPR in processing your employees' data. Does that make sense?
Yeah.
Okay. Okay.
Okay. Now, as it relates to your activities as a company, not necessarily employee data, your employees are going to be in the EU and they're going to be processing data of other people. On what basis? Because the first thing I'm thinking about now would be for if you can look at the slide under territorial scope B2,
Yes.
for the if it's for the monitoring of their behavior online, as far as the behavior takes place in the EU, you're definitely caught.
Okay.
And I don't know if that is it, but I'm assuming because that's what I can think of when I hear Facebook.
Mm.
And then if it's for offering of goods and services, and you're going to be processing data of individuals who are in the EU, then as an entity, you would definitely be caught. So does that make sense?
Yes, it does.
All right.
It does. Thank you so much. Thank
You're
you.
Yeah.
Okay.
Okay. Okay. Wow. Just when I thought we were almost done, Nina has another question. So, but before I take Nina's question, or after we take Nina's question, and since it seems we still have some time because this webinar was scheduled for 5 to 7, I think we may just want to rub minds on how we handle, I mean, for us to reflect on how we handle employee data in our different companies, since many of us, or quite a number of us, are in council. So I'll begin to start reflecting as businesses and as individuals. One, on how we treat or advise our companies to treat employee data. And then secondly, how as individuals working for these companies or generally, we perceive our own data being used. Because I think to a large extent, and I speak for myself, we do not seem to really bother much about how our data is used. Just 2 days ago, I was at a mall trying to get an internet modem, Intel, and in registering my SIM, they were asking a number of questions, of course, for the registration, my name and all of that. So, but when they got to a point, they were asking me, what is your mother's name? I said, what has my mother's name got to do with registering? And he said, you just have to give us. And then I just remembered something about, maybe it's in GDPR or whatever, that you should only ask for minimum information. I think that's how it's put, Josephine.
Yeah. Data
Yes.
minimization only for what is required
Yes,
for the
yes,
purpose.
data minimization. You should only ask for minimum information that requires you to do what you want to do. And I was asking the lady, how does giving or not giving you my mother's name, prevent you from registering this SIM? And then of course I ended up not buying it anyway because I was just so pissed when she said, it's either you give us your mother's name or we won't sell to you. I said, ah. So, and I think those are the kinds of questions we need to start asking. Uh, what local government are you from? What's your religion? How many wives do you have? Where, I think we should begin to ask questions, really. So, rub minds and ideas on all that after Nena's next question or comment, whatever it is. And you're unmuted now, Nena.
Thank you so much, Jamil. Jojo, I just wanted clarity on your response to Indamala's question on whether her employees will be liable for the work they do, as in while handling third-party data while working in Facebook offshore.
What do you want to clarify?
I just need clarity on how you answered Indamala's question
So
on
I said
whether.
Right.
I'm listening.
Okay. So I said that it was two things in the context of employee, in the context of employment relationship, employer and employee relationship, right? Because she's a Nigerian entity and she's in Nigeria, she's not in the EU. If you I have the slide up still. So if you look at A of territorial scope, that's what I'm looking at it under. It that what because that deals with entities in the EU, which her entity is not. Her entity is in Nigeria, right? And it deals with processing in the EU or not. So since she's in Nigeria, her entity is in Nigeria, she wouldn't be caught under A for processing employee data. She wouldn't. I don't believe she would have to process the data of her employees who are now in Facebook in accordance with the GDPR. I don't think she's caught because A is the only place, like I said earlier, where I think employee data falls. But Facebook, because Facebook is an establishment in the EU, if Facebook would be processing her employees' data, then Facebook would have to do so in accordance with the GDPR. That's the first part. Okay. It's clear up to that point. Then the second aspect of it is where she said she took it away from employee data. And she said that her employees who are in the EU now would have to process data of other people. And I said that could either, I said because it's Facebook, the first thing that comes to my mind is the BII part, that they'll be monitoring and they'll be processing that data for the purpose of monitoring the behavior of those other people whose data they're processing. If that is the case, then her entity in Nigeria is caught.
Okay.
If it's not monitoring their behavior, but they're offering goods and services, then yes, her entity in Nigeria would still be caught.
Okay, thank you. If I may just chip in, I'm just thinking that if the employees of that Nigerian company in Facebook were actually processing or handling third-party data while working with Facebook in the name of Facebook, then Facebook will be the one to will actually be the party to be liable to the third party, and Facebook could under what's the word now, vicarious liability, then seek some kind of recourse from the Nigerian company whose employee that was seconded to Facebook had committed the breach. I'm just thinking that perhaps that's how that may be.
Please say that again.
Okay, I said just thinking aloud, because the employee was actually seconded to Facebook and was dealing with third-party data with Facebook as, you know, to the outside world, that employee seemed to be an employee of Facebook to the outside world. So because the data was dealt with in the name of Facebook, Facebook will be the party to be liable to the third party. And Facebook can then seek recourse from the Nigerian company.
Oh, okay, I see. Yeah, I think so.
Thank you.
Okay. I'll pretend I understood all the things that the lady said just now. We have just about 10 minutes to go. Can we spend, is there anyone who has any general comment to say on the reflections I mentioned?
Yeah, I think
yeah.
Okay.
After the speaker for the day.
Okay, Josephine.
I said I've been thinking about it, and what I think about it, Jamie, is just it's part of our culture. We're nosy as Nigerians, and that's why sometimes we can't wrap our brains around privacy issues like this and saying why it has to be ensured. The average person would ask you, if you say you walk into a place and say you went to the hospital, the average Nigerian will ask you what's wrong with you. The average boomer will not ask you. He just say, hope you're okay and move on. It's like we generally just see things as if we have a front row seat to other people's lives and we can ask any and every questions. So even if we have a data protection act, our mindset about things like that, about information, would make implementation of the act even weak, just because we don't necessarily see the need to hide things from people or to not ask people certain invasive questions, things like that. That's one. And I think the second thing is just we don't pay attention to things like this. We don't think about things like this because it doesn't make sense why in Nigeria you have to give your BVN to get a SIM card. They don't need your BVN for that. Oh, no, not your BVN, sorry, your biometric data to get a SIM card. It's absolutely unnecessary. Like your biometric, once they happen to one system in Nigeria like this, all of us are dead because all our information is everywhere. Biometrics is now
I reject it in
everywhere you
Jesus'
go.
name. I'm not dead.
Okay, until they be like your biometrics is everywhere, and it's just like, why do you need to give your biometrics to people everywhere you go? Why do you need your biometrics? Like we're saying about your mother's middle name. Why do you need your biometrics for a SIM card? Like a SIM card is something you should be able to use. I don't know, but I think that is just a bit about the mindset we have as people generally and how we view information of other people.
Hmm. Okay. And then you wanted to say something?
Yes, Jamil, in addition to what Josephine had said, I had actually been in that kind of situation in the past where I was asked to provide information up to my village, as in the local area in my village. And I challenged that request and was told in response that it was just to be able to ascertain, my personality as a Nigerian and claim as to who I am. And the question is, how are they sure that the information I've provided is actually correct? Are they going to verify it? I think part of the problem we have is the government's inability to have a proper data room for all Nigerians. So at every point you get to provide that information over and over again. I think initially they said one of the purposes of the BVN was to bridge that gap and have at least the data of people who have bank accounts. But it doesn't appear that that is helping the situation. So, and again, coming to questions as to religion, we have a constitution that prohibits discrimination on grounds of religion, for example, but we actually do things that project that kind of discrimination, asking for someone's tribe, religion, and other information that are really not healthy or necessary for fostering national unity. So I think the earlier each of us begins to kick back, like if you are asked a question on your religion, for example, not providing it, or your tribe, for example, not providing it, perhaps that's going to force some kind of conversation on that to get it out of our national system.
Great. That's a great contribution. Thank you. Let me ask one or two other people before I do my closing introduction. Akit works with Sterling Asset Management. I'm sure she might have something to say about how they use their employee data and any advice you would have for in-house counsel who needs to advise on data privacy. Akimat, you're on.
Okay. Hi, everyone. Okay, basically, I think what I want to talk about is more in line with what Nina just spoke about. The fact that there's no uniformity of data. You go and register for your international passports, you do thumb printing, you want to register for with Securities and Exchange Commission, you go through the whole process again. And a lot of people ask for irrelevant information, as it has been earlier discussed. So I think in Nigeria, we should work towards unifying everything. For instance, I'm so sorry, this might be outside Ireland, like the accidents that happened in Lagos yesterday. I'm very sure that right now they won't be able to account for everybody. Assuming we have like a universal data bank or database, and where proper records can be kept and everything, it would really go a long way to help, and they can eliminate a whole lot of bottlenecks. That's all. Thank you.
If I may say something,
Yes.
I'm just thinking, um, when you mentioned like the suggestions about the data room and unifying it, I'm thinking about it in the context of the GDPR. I know
Okay.
that the GDPR may not apply, but I'm just thinking I'm taking the GDPR now as just international best practices or whatever to consider, and just looking at it in that light. It may still be necessary to have to give your information at every place, because remember that they have to collect your information for a specific purpose, and they shouldn't disclose it to another organization for a different purpose. Do you understand? So it may still make sense and may still be safer, because when I say safer, I said safer because each regulatory body or each entity that takes your data has to be responsible for your data and has to be responsible to have appropriate safeguards to protect your data from breach. If everything is just in one place, it's like putting all your eggs in one basket. Once that is breached, is breached. But if each entity is responsible for protecting data and is responsible for having adequate, appropriate safeguard measures for protecting this data, then it's different. I feel like it may just be a little bit more secure. And you can also trace data breaches to the source. So you can say this, if you have a common pool and everybody just goes there to collect data, I feel, I'm not a tech person or whatever, but I'm just thinking that it's more difficult to identify or to pinpoint where a data breach comes from.
Comes from. Okay, I understand you. So I think we should go more in line with protection. Okay, for instance, all these vendors that when you want to buy things from them, they already have your phone number and everything. How far are we sure that they're not circulating our phone numbers or any other data they have about us to people that are not meant to have them? So I think we should look towards more of protection in Nigeria.
Yeah, definitely.
Yes.
Okay, I'm going to unmute and everybody. If anybody else wants to say something generally before I close, anybody? Comments? Bayo? Nee? Okay.
Okay, for me, I just want to say
Thank you
thank
so much.
you.
Well done, Josephine. Thank you, everyone.
Thank you,
I
man.
haven't closed though. I was just asking for general comments.
Oh, sorry.
Oh, I see. Yeah. And then I since you wanted to say something.
I was just saying a very big thank you to Josephine. This is actually a lecture in itself. I was
Yeah.
expecting like a 30 minutes talk, but this has set a very, very harsh standard for everyone going
Thank you
forward.
very much, Nana.
Yeah.
All presenters, thank you. And
Thank
for
you.
us as a group, as Elan, thanks to everyone who has participated in today's talk. Thank you so much, Jeremy, for all the effort that you have put in towards making this success. And I hope that we will continue to grow and do greater things to develop
Yeah.
the country. Thank you.
Oh yeah, the country. Thank you.
The country.
Yes. Let me develop my little case first.
I'm still
Yes.
thinking about that Uber question. I will not lie.
Okay. You have an
Which
answer
of
now?
it?
Uber, I think it can be either way. I think it's just one
Yeah.
of those things that you can argue depending on who is paying you. I think
Yeah.
because it would depend on because
Yeah, just Jojo, on that, still on that Uber question, you had mentioned that if the person just has your phone number and no other like no other personal information directly from you, then
yeah,
the GDPR may not apply. I don't know. I think that was what I
yeah.
heard.
But I'm
So, but
thinking about
yeah, with somebody's phone number, you can get 1,001 things about that person.
exactly what I was thinking about now. I mean, if I get your phone number and I call you, I'm going to know who you are. So your phone number is almost like your name.
Like I always
Okay.
tell people that this
Yeah.
idea of having caller is actually criminal. Just give your phone number to someone and they have your details because they just Google your name and get all the
Everything.
information. Your name pops up and they can get everything they need to know about you. So I hope that the EU who is taking
Truecaller
the
does
fight.
not work here.
Oh, really?
It does not work
That's
here.
one of the things.
Ah,
Really?
come on. You
I
people
know
have turned
somebody
it
in
to,
the UK.
market gist. I beg. Let me
I
look
think
properly.
Josephine, I think they have something synonymous to Truecaller
I'm putting
because
you on mute.
recently I gave somebody my number in the UK, and the person was able to get almost everything that was about me on the internet
Oh, I see.
just from that phone number, and the person got my full name and all of that. So I don't know what the name of the app is.
It might be Truecaller. It might be Truecaller, but it might be because you are in Nigeria. Truecaller cannot work
Okay.
for me for somebody who is in the UK.
Is there an app that is similar to Truecaller though?
Not that I'm aware, and I not that
Okay.
I'm aware.
Okay.
Okay. Thank you for allowing me to come in at this time. Thank you to everybody who has joined this session. This brings the session formally to an end. Next month's session will be on managing large-scale redundancies, and it's going to be anchored by Nden Naize and Adetutu Dufuye, who are legal counsel in Tutu is a legal counsel in Nokia Alcatel. And then I always forget that your company's name because anything that has a number I forget. Remind me again. FHN 34 or what?
First hydrocarbon Nigeria, damn you.
Sorry.
First hydrocarbon Nigeria.
Oh, now FHN now.
Mm-hmm.
It FHN First Hydrocarbon Nigeria. Legal counsel with FHN First Hydrocarbon Nigeria. So it's going to be on large scale, managing large scale redundancies. These are two ladies who've had extensive experience with managing redundancies, aka laying people off. So it's wonderful experience. That will be next month, and we hope to see you then. Have you join us? The recording of this session hopefully will be made available to everyone today or as soon as possible. Yes. Okay. So thank you all, and have a great weekend.
Thank
And
you.
you too,
Thank
Jamie.
you.
Yeah.
Bye.
Thank you,
Thank
Justin.
you.
Bye.
Thank you.
Take, don't kill me.
Akimat, who is killing you?
No, I'm Atadiola Odekujare. It's all those young boys that beg for me money.
The call is still on.
Oh, sorry. Let me exit. Let me leave the call. Bye bye.
Tommy, how are you?
I'm fine, thank you.
I hope you enjoyed the session.
Yes, I did. Thank you. It
Great.
was very enlightening.
Yep. Okay.
Thank you
Take
very
care.
much. All right, bye.
Bye. Take it off.